Welcome back to the deep dive. Today, we're opening up the legal playbook for a profession that's pretty unique in Canada. We're getting into the legal pillars, the rules that give professional engineers and geoscientists some special authority, but also, special responsibilities. Think about it. These pros get legal powers because their work. It directly impacts, well, public life, safety, health, huge property values. So, our mission today is to really dive deep into the two big legal structures holding this up, the right to title and the exclusive scope of practice.
Absolutely. And this is really key stuff, especially if you're aiming for your license, getting ready for the National Professional Practice Exam, the NPPE. These aren't just abstract ideas. They're the actual legal tools that protect your professional integrity and, maybe most importantly, keep that public trust. That's what the whole Canadian system is built on.
Yeah, we want you to feel totally comfortable with these ideas, whether you're seeing them in study guides or, just in your day-to-day work. So if mastering this NPPE knowledge is on your radar, definitely hit that subscribe button right now. We're really focused on making sure you get the clearest possible take on these really crucial professional duties. Okay, so let's start unpacking this. We talk about these professions policing themselves, self-regulation, but where does the actual legal muscle come from? How do they enforce anything?
Well, what's interesting, and maybe a bit surprising, is that it's provincial law that governs engineering and geoscience, not federal. That's why we call it self-regulation. The power doesn't come down from Ottawa. It flows from specific laws, actual acts that are set up in each province and territory. Each one's a bit different, but the core ideas are the same, right? And these provincial acts, they're the starting point for everything legally. They spell out basically three core things with legal force. One, who is actually allowed to practice the profession. Two, who gets to use those protected titles, P.eng, P.G.O.
Yep.
And three, what specific work falls under that exclusive scope of practice just for licensed pros in that province or territory.
Okay, that sounds, well, incredibly powerful. But, playing devil's advocate here, if the profession is policing itself, doesn't that raise a flag? Like, isn't there a potential conflict of interest built right in?
That's a really vital point, and it's exactly why the professional associations, like PEO in Ontario, APIGA in Alberta, Engineers and Geoscientists BC, they aren't just clubs for members. They're actually legally mandated bodies. The provincial laws give them the power and the obligation to regulate in the public interest.
Okay. So not just for the benefit of engineers, but for everyone else.
Exactly.
Yeah.
Their job is twofold. First, set really tough standards for who gets in education, experience, ethics. And second, regulate how their members behave and go after unlicensed people who are breaking the law.
So the government basically delegates its power to these associations, and they have to act almost like a proxy for public safety.
Precisely. And the consequences for breaking these rules are serious, specifically because public safety is often on the line. So, if someone without a license uses a protected title, or offers services they aren't allowed to offer, or, crucially, signs and seals technical documents like they're a licensed pro, they're breaking the law, that provincial act. And it's strictly enforced.
What does enforcement actually look like? Fines, jail time.
Well, when we talk enforcement, the regulator, the association, has tools. They can issue some pretty hefty fines. We're talking potentially tens of thousands of dollars, especially for repeat offenders. And importantly, they can go to court and ask for an injunction.
An injunction, like a stop order.
Exactly. It's a powerful legal move to immediately stop someone, or even a company, from doing unsafe or illegal work. It protects the public right away while the whole prosecution thing plays out.
Okay, that level of authority, that really brings us to the first pillar you mentioned, the right to title. This is the public's guarantee, right? Can you lay out what that means, this right to title?
Sure. So when we say title, we mean those specific letters after someone's name. Only people who are actually licensed, meaning they've jumped through all the hoops. Accredited degree, years of supervised experience, passed the ethics and law exam, the NPPE, only they can legally call themselves a professional engineer or a professional geoscientist. Geoscientists. And of course the French versions too, in Geoscientists and Geoscientifique. Right. And the whole point of protecting these titles is assurance. It's a signal to the public. When you see P.eng or P.G.O., you instantly know that person has met national standards, they follow a strict code of ethics, and, critically, they can be held accountable, they can face discipline if they mess up. It's a mark of credibility, guaranteed by law.
Can you give us an example, maybe one that trips people up?
Sure. Let's say someone has a fantastic engineering degree, top of their class, but they haven't finished their required work experience yet, or maybe haven't passed the NPPE. They might be working inside a company with a title like engineering analyst or project coordinator. Now, even with that great education, they absolutely cannot legally put engineer or PE
Yeah.
on their business card, in their email signature, or represent themselves that way publicly.
Why not, if they have the degree?
Because the title isn't just about education, it's about the license. It signifies that they've met all the requirements and are now legally accountable to the regulator and the public. The education is necessary, but it's not sufficient on its own for the title.
Okay, this is where it gets tricky, especially today. I think a lot of people studying for the NPPE run into this. You see job titles like software engineer or mechanical engineer used all over the place in industry, particularly tech. If the job itself doesn't seem to involve, say, designing a bridge, no obvious public safety risk, why is the title itself still so heavily guarded?
Yeah, that's a constant point of friction, and it really gets to the heart of the legal principle here. In the eyes of the law and the regulators, the title engineer or geoscientist is protected regardless of the specific tasks in a particular job description at that moment.
Really, even if the work is purely internal.
Yes, because the title itself implies a certain level of competence, ethical obligation, and legal accountability that only comes with licensure. Using the title without the license, even if the work itself isn't technically reserved practice, is seen as misleading the public about your qualifications and standing. So companies that use titles like project engineer for staff who aren't licensed PAs, technically they could be seen as contributing to illegal practice under the Act. That's why you sometimes see these legal challenges pop up. Remember the discussions around Microsoft Canada years ago? Regulators pushed back on how the title engineer was being used for software roles to protect the meaning and integrity of the professional designation. It's about preventing public confusion.
Fascinating. So Pillar 1, right to title, is fundamentally about who you are legally, your accountability. That sets up Pillar 2, the exclusive scope of practice. This sounds like it's about what you can legally do. How is that defined across all the different provinces? Is it consistent?
It's broadly consistent, yeah. While the exact wording in the provincial acts might differ slightly, the core idea defining the exclusive scope revolves around activities where incompetence could cause real harm. Generally, work falls into this regulated scope if it meets three criteria. One, it requires applying specialized engineering or geoscientific principles. Two, and this is key, the work affects public life, health, property, or the environment. And three, it demands independent professional judgment and taking responsibility for that judgment.
Okay, let's focus on that second one. Affects public life. That feels broad.
Yeah.
Can you give some really concrete examples of work that absolutely falls under this exclusive scope, stuff that needs a PE or PGO stamp?
Oh, definitely. For professional engineering, think classic infrastructure projects, designing a highway bridge, calculating the structural loads for a high-rise building, designing a large dam, or maybe designing a complex industrial system like a chemical plant or a municipal water treatment facility.
So things where mistakes could be catastrophic.
Exactly. You're taking direct legal responsibility for calculations and designs where errors could have severe consequences for public safety or the environment. For professional geoscience, it could be things like mapping underground rock formations to find safe drinking water sources, doing complex environmental site assessments before construction, or evaluating geological hazards like landslide risks for major projects.
Okay.
Again, the common thread is applying specialized knowledge where the public safety or welfare hangs in the balance. It requires that professional judgment and accountability. That's why it's reserved for licensed individuals who've proven they meet those high standards.
What about things like manufacturing or maintenance? I often hear people distinguish between, say, the initial design versus just building the thing according to plan or fixing it later. Does the scope cover all of that?
That's a good clarification. Generally, the exclusive scope is focused on the design, the analysis, the certification of the system or structure that impacts public safety. So once a P.eng has designed and certified, say, a machine, the routine manufacturing of copies of that machine according to the certified plans, or maybe routine maintenance following a prescribed manual that often falls outside the exclusive scope.
As long as they aren't changing the design.
Right, as long as it doesn't involve altering the core certified design or require independent professional engineering judgment to solve a new problem. The key is, does this task need a fresh application of core principles and someone taking professional responsibility for it? If not, it might be work for technicians or technologists operating under established procedures or the original certification.
That helps clear things up a lot. Okay, let's
Right.
connect these two pillars now. We've got misusing the title and we've got doing the reserved work without a license. What's the practical difference in how a regulator sees these? Is one worse than the other?
They're definitely separate violations, targeting different kinds of harm. The right to title violation is fundamentally about misrepresentation. It's about preventing someone from misleading the public about their credentials.
So calling yourself engineer when you aren't licensed.
Exactly. It's an offense against public trust and clarity. Now, the exclusive scope violation, that's about stopping actions that could physically endanger people or the environment. The offense there isn't just what you call yourself, it's what you did designing that bridge, approving that geological report for a foundation without the legal authority and the demonstrated competence and accountability that comes with a license.
So which is seen as more serious?
While both can lead to prosecution by the association, unauthorized practice, the scope violation, is almost always viewed as the more severe offense
Why?
because it carries a direct, immediate risk to public safety, health, or property.
Right. Okay, so these professional associations, they're wearing two hats then. They're like the external police going after unlicensed folks breaking the provincial laws. And they're the internal regulators dealing with their own licensed members if they mess up negligence, ethics violations, that kind of thing.
That's it, exactly. It's a holistic system meant to cover all angles to protect the public interest. Now, we should also touch on exceptions, because this definitely comes up on the NPPE. The acts aren't meant to stop all technical work by non-licensed people.
Right. That would grind everything to a halt.
Pretty much. So the law makes allowances. There are limited exceptions, for example, for students or engineers in training, provided they are working under the direct supervision and control of a licensed professional. That supervision has to be real and documented. There's also room for technologists and technicians to do important technical work. But again, the line is drawn when the work requires independent professional judgment in those safety-critical areas defined by the scope. Their work usually follows established codes and procedures. And academic research or teaching is generally outside the scope too, as long as it's not being offered as a professional service directly to the public.
But, and this seems like the crucial point, tying back to Pillar 1, even if someone falls under one of these exceptions for the work, say an intern or a technologist,
Yes.
they still can't use the protected titles, right?
Yeah.
P.eng, PGO, that distinction stays firm.
Absolutely firm. That's non-negotiable. The exceptions apply to performing certain tasks under specific conditions, never to using the protected professional titles. The title is exclusively for the licensed individual.
Okay. Let's circle back to that industry confusion we talked about, especially in tech. We see software engineer everywhere. Most software maybe doesn't fit the traditional definition of affecting public life like a bridge does. Yet regulators are clearly concerned about the title use. What does this whole situation tell us about where these laws might be heading?
It tells us the regulators are in a constant state of, well, trying to adapt. They're applying laws, some written decades ago for physical infrastructure, to brand new, often borderless digital industries. The big challenge for them is figuring out when a new field, think complex AI systems controlling medical devices or self-driving car software or maybe even financial algorithms, crosses that line. When does it stop being just technology and become an activity that now needs independent professional judgment because it directly affects public safety or welfare in a significant way?
So it's an evolving definition of public welfare.
Kind of. That tension is exactly what drives those legal fights over title misuse. It's the regulators trying to maintain the link between the professional designation engineer and genuine legal accountability, especially as technology pushes into areas with potentially huge public impact.
That really highlights how adaptable future professionals will need to be. Okay, one last practical piece. If someone is licensed, say a P in Alberta, and they want to work on a project in BC, how does that work with this strictly provincial system? Is it a nightmare?
Thankfully, no, it's usually quite streamlined. There are national agreements in place, like the National Mobility Agreement or various inter-association mobility agreements, specifically designed to make it easier for licensed professionals to practice across Canada.
So minimal hassle.
Relatively minimal barriers if you're already licensed in good standing somewhere else in Canada. However, and this is important, you still have to follow the rules of the province you want to work in. You absolutely must register or get a temporary license in that new province or territory before you start practicing there. It's not about proving your skills all over again. It's about officially putting yourself under the authority of the local provincial regulator. They're the only ones with the legal power to oversee practice in their jurisdiction.
So you're basically just switching which regulator you're accountable to.
That's a good way to put it. You need to formally establish that accountability link with the regulator in the place you'll be working.
Got it. That really paints the full picture. This whole complex setup, all of these laws and associations, it really boils down to one main thing: protecting the public.
That's the bedrock.
Title gives the credibility, the assurance, and the exclusive scope ensures the competence and safety for that critical work.
Precisely. The two pillars work together. The title identifies the credible, accountable professional, and the scope defines the high-stakes playground where only that professional is legally allowed to play because of the risks involved.
This has been incredibly helpful, really getting into the foundation of professional practice in Canada. I think the core takeaway is pretty clear. Title is about who you are legally. Scope is about what you can do legally. Get those two straight, and you understand the bedrock of your professional responsibilities.
Absolutely. And maybe a final thought for you to chew on, especially looking ahead. As technology just keeps accelerating, think about fields like AI, complex systems, biotech. How are the old legal definitions of professional judgment and affecting public life going to be stretched or challenged next? Understanding that evolving boundary, that's going to be critical for the future of self-regulation and for professionals navigating their careers.
That is definitely something to think about. A great point to end on. So, if you found this discussion useful for figuring out your career path, especially if you're gearing up for the NPPE, make sure you subscribe right now. We do deep dives like this specifically to help you succeed on that exam. Thanks for joining us, and we'll catch you on the next deep dive.